Hi everyone, welcome to episode 11 of Fridays with FEMA. This is Ashish.
Hi, I'm Janisha.
So, taking forward our discussion on NDI rules, I think today let's start with discussing a little bit about FDI and FPI, right? I think
Mm.
very complicated terms after the NDI rules provided for the definition of these since they came in, right?
Yeah,
I think let's speak about that in a more Schedule 1 and Schedule 2 context and what is really FDI, what is FPI investment,
Mm.
and is there something a third which is a non-FPI investment? Is there something like that? And then let's talk about that.
sure. I think so. Let's take a step back and let's understand how if foreign direct investment and foreign portfolio investment have been defined under the NDI rules.
Sure.
So, any investment in an unlisted company by a non-resident is considered as foreign direct investment.
Hmm.
It's a parallel to the definition of ODI in
Right.
the ODI context. Um, With respect to the listed company, if the non-resident is investing more than 10% in the listed company, it's considered as foreign direct investment. If the non-resident is investing less than 10% in the Indian listed company, it's considered as foreign portfolio investment. Again, a very similar parallel to the whole OPI definition
Correct.
under the OI laws. So, however, since the time they've been introduced, there's been a lot of confusion as to whether they qualify the route of investment or not. So, in our previous episode, we spoke about different schedules through which the non resident investor can invest in an Indian company, right? There is a Schedule 1 route which talks about which talks about how a non-resident can invest in an Indian company subject to sectoral caps, conditionalities, etc. And Schedule 2 talks about investment by foreign portfolio investors who are SEBI registered category of investors, right? So, so there's been a lot of confusion that if I'm investing in a listed company, if a non-resident is investing in a listed company which is less than 10%, and that's called as foreign portfolio investment, does it necessarily mean I have to be an FPI or a foreign portfolio investor
Correct.
registered with SEBI to undertake the investment or not? Right. So, does that mean that if I want to do a foreign portfolio investment, which is less than 10% in a listed company, does it mean I necessarily have to go under Schedule 2 of the NDI rules? Right. And I think this debate has always played out, continues to play out. Right. To my mind, I think that's not the case. Foreign portfolio investment qualifies the investment, not the mode of investment. So you do not need to be a FPI or a foreign portfolio investor investing through the Schedule 2 route. In that situation, you can also, as a non-resident, undertake an investment in the listed company under Schedule 1 route. If the company is doing a primary transaction, you can very much, that's one instance through which the non-resident can acquire the shares, invest in the shares of a Indian listed company, and that may be below 10%. So if that is below 10%, it will be considered as a foreign portfolio investment. One of the most common repercussions of that is there is a filing which an Indian company needs to make when it allots shares to a non-resident. That's
Right.
called Form FCGPR. So if it's a foreign portfolio investment, the FCGPR is not the filing that gets triggered, right? So the point I'm trying to drive is the definitions of FDI and FPI does not qualify the mode of investment. You can still invest in a listed company less than 10% if you are complying with the Schedule 1 route. Schedule 1 route has a very stringent requirement in for undertaking which non-resident can undertake a stock market transfer. So most non-residents may not be able to comply with that, but you can definitely acquire shares of or invest in the shares of a listed company through a primary transaction by the listed company. In some cases, we've also seen off-market transactions. So that can still be done under Schedule 1. That may still be done under Schedule 1 even though it's below 10%
So, maybe to summarize, so we of course have FDI, which is more than 10%,
for a
and
listed
for a
company.
listed
Yeah.
company. Then we have what I would put it as a pure portfolio investment, which is less than 10% under Schedule 1, where we have to follow those conditionalities which are quite stringent. And then under Schedule 2, we have a foreign portfolio investment, which is basically any foreign entity which is registered as a foreign portfolio investor who can then make investment into
As
the
per
Indian
the
listed
Schedule
company,
2
which is
routes.
anyway going to be less than 10%, and as per the
Schedule 2 route.
Schedule 2 route. So that's the
That's right.
yeah, I think that's something that we should all be very careful about and understand which route we are coming into and which route we want to invest into, because even below 10% you are able to do a portfolio investment at Schedule 1 if permissible, and you do not need to form an FPI, or you do not need to go via an FPI to make that
That's
investment.
right. So well summarized, Ashish. I think that's correct.
Sure.
So yeah, I think that's on this point.
Okay, wonderful. I think the second point that today we are discussing is basically, since we're talking about the schedules. So I think when we are doing a due diligence, right, Janisha, I think what becomes important to be seen, especially in case of startup companies, is that what is the business they are into, right?
Hmm.
And now, if there is a non-resident who's going to be investing into this startup, this will become an FDI investment, going to fall within the NDI rules, and you have to follow what the sectoral caps, pricing guidelines, etc., are provided for under NDI rules. Now, how important does it become for these startups to one, be clear about what they are doing in India, and two, how does that, what role does that have to play from an NDI rule perspective, especially if there is an non-resident who's making the investment?
Sure. So while the question is for any company in
Of course,
India
yeah. I think
which is
start,
taking
yeah, yeah.
startups is just a case in point because probably out there things might be a little more muddled. Okay, so I think let's take a step back, right? Schedule 1 provides for investment by a non-resident into an Indian company subject to compliance with the sectoral guidelines set out in Schedule 1, right? Schedule 1 provides for this table where there are specific sectors set out and against which it is clarified whether how much foreign investment is permitted in that sector, in that company, if it's in that sector, 100%, 50%, 49%, whatever it might be. Most sectors today 100% is the norm. Then whether that investment is under the automatic route or approval route, right? So automatic route would be you don't need any approval from the government. If it's under the approval route, that means you need approval from the government as per their SOP, right? And third is even if the sector in which you want to invest in, it's 100% FDI is allowed and there's no government approval required, which is for most sectors today, there might still be sector specific conditionalities that you need to comply with, right? And the primary Schedule 1's category, while the obligation to comply with NDI rules is on the non-resident as well as on the resident, but Schedule 1 very categorically calls out that the onus to ensure compliance with sectoral caps and the conditionalities is with the company receiving the foreign
Sure.
investment, right? So it becomes very important for the foreign investment and definitely also important for the non-resident to be sure about which sector they are categorizing under before the foreign investment comes in, right? Also, one more thing, that if a particular sector is not mentioned in that table under Schedule 1 of the NDI rules, then it's deemed that foreign investment up to 100% of the share capital of that company without any approval and without any conditionalities can come in.
Sure.
Yeah.
So let's talk this through, right?
Yeah.
I think let's take the example where there is an Indian company which is basically doing development work, development of software, development of
Hmm.
information technology related
Sure.
activities, right? Now, would this be a 100% automatic route?
Yeah, it will be because ITAS is not specifically set out in the table, so it would be deemed to be 100%
Sure,
permitted. Yeah.
sure. So now let's take this example further, right? Now there is this development entity, if I may call it, but at the side they have also prepared this fintech platform using the digital
Hmm.
technology that they have, right?
Right.
Now, would that still be 100% 100% automatic ITS, or would that fall somewhere else?
Okay, so to answer that question, one thing which we need to keep in mind is that the all the business activities undertaken by a company, all of them should fall, need to be categorized with respect to the relevant sectors, right? So in your example, let's say one division of the company is into pure IT, which is fine, right? But The second division of the company is, into the financial services sector, right? So financial services is the table does provide for foreign investment financial services, and there is a broad catch-all category of other financial services, right? So if the activities are registered or regulated by any financial services regulator like SEBI, RBI, RDA, then 100% foreign investment would be allowed, without governmental approval. But if you're not registered or regulated by any of the financial services regulator, then you cannot you need to take governmental approval for the foreign investment. So what will be very important is to evaluate that the second limb of fintech, is it are you I mean, you can still call it under ITEAS. That's what I mean, because we're talking about fintech, that's one categorization that's very commonly done. If you're going under OFS, other financial services, are you registered or regulated by the financial services regulator? Are you not? And accordingly, you need to do the risk matrix. But what is very important is, even if 99% of your revenue hypothetically is coming from the ITEAS, only 1% is coming from the fintech category, it doesn't mean you disregard the fintech
Right.
category. FDI analysis does not work with respect to the substantial revenue test, right? Even if a particular activity is fetching you 0.01% of the revenue, you still need to ensure that that activity is such that foreign investment can be permitted without conditional or without
Sure.
any approval
So
requirements.
yeah, sure. So I think what you're saying is that if I am into 100, if there are two things that I'm doing,
Yes,
and if one of the activities is a 100% automatic route, which is ITITS in our example, then the other activity also that
has
I'm
to
do,
be, or you go
no,
and take approval, of
yeah,
course.
exactly.
So
So the way to think about it is that if both activities are 100% automatic, then
then you can go
yeah,
ahead.
then you can
Yeah,
go ahead. Otherwise, you need to go and
yeah,
take approval or meet. I mean,
correct,
meet whatever other conditionalities as may be prescribed. Though,
correct.
if it is a 51% allowed sector or 49% allowed sector, then you would have to go for approval because you are trying to do two
Exactly.
businesses under one
Correct,
roof,
correct. Because
right?
there's a lot of, there's a lot of myth, especially amongst clients, companies, etc., where they're looking at the substantial business and they are doing the evaluation, especially if you've not taken
Sure,
assistance of a professional advisor, and anything which is like non-revenue generating, but it's still there, right? So you can't simply disregard that when you're doing an FDI analysis.
sure,
So Ashish, because we are on this point, right? Two more points I wanted to make. One is, how should we go about doing this analysis, right, as lawyers, and what do we typically do, and what companies can keep in mind
sure.
to be prepared about something of this
So,
sort?
sure, I think that's a great point. I think just taking one step back, right? I think we spoke about IT, ITS, and fintech. I just want to clarify for everybody who's watching, right? In an MBRT, SBRT situation, and how this would work, right? Now, if you are doing single brand, there's 100% automatic is allowed, but under MBRT, that is not allowed. Now, if you are doing manufacturing, and with that manufacturing, you are also doing MBRT, right, which is multi-brand retail trading. See, that again is this position where you are doing 100% automatic for manufacturing but not allowed for
Yeah,
MBRT.
basically the same entity can't do one activities which is permitted and another which is not permitted.
Correct.
That, and then you can't just do it under the automatic route. That
Sure.
that won't really work,
Yeah,
right?
sure. I think, yeah, that's the point that I was also trying to make. Wonderful. I think now you could go ahead and tell them how,
Sure.
yeah,
So
we
I
should.
think the test is A, of a factual test, and second is a document based
Right.
test, right? So when a particular company tells me, what am I doing? And they'll say that we are traders, okay, very loosely put. But it's important to get into their entire business model. Like, what's the step one? Are they manufacturing the products, or is a third party manufacturing the products, or are they procuring the products from wholesalers? What is it that they're really doing? You
Right.
need to, I'm just giving this as an example. You need to get into the granularity to understand factually how is the business model working, because
Right.
it can make a huge difference, right? If, let's say, they are simply importing products, or let's say they're just simply taking products from a wholesaler and selling it on retail basis, they will be considered more in lines of a single brand retail trader. But if they're actually manufacturing the products and still selling it to end consumers, then including through third party contract manufacturers, then they would be considered as I mean, they would be considered in the head of manufacturing from an FDI perspective. And single brand retail trading has a lot more conditionalities to be complied with, whereas manufacturing barely has any conditionalities to comply with. So
Right.
depending on actual facts, it'll be important to structure the categorization accordingly. So one is facts, but those facts also have to match the second point, which I called is the documentation,
Right.
right? You need to evaluate the memorandum of association of the company. You need to see their annual returns. You need to see the financials. What has been recorded to be the core business of the company? In the financials, there is this identification of where the maximum revenue is coming from. You need to see those things because that has to match the story that they are telling you, right?
Right.
You also need to see the approvals, the license, the trade license, whichever other license, the IEC code. There's always a category mentioned there, right? So those points are also important to be factored in. A lot of times, because of lack of too many heads, somebody might categorize themselves as a trader, but actually they're a manufacturer. That's okay. But the point is that you still need to be cognizant of what is the paperwork saying, and what paperwork, there's no option but to, just keep it as is, or what paperwork may need to be amended to actually sync it
Fall within
with
the,
the
yeah.
factual matrix that they've spoken about, right? So I think this is the exercise that's relevant to be undertaken when we are we are identifying which sector we are falling into.
Sure. Okay, I think that's great. I think it was great to talk about this. We'll end it today and hope to see you guys again next week with something more under the NDI rules. Thank you.
Thank you so much.